Morning, everyone. Thank you for joining me today on this webinar that I'm going to discuss the Americans with Disabilities Act in our Tennessee Judicial Branch ADA policy. My name is John Koch, and I am one of the couple different hats here I wear at the AOC as the Judicial Program ADA Coordinator. And most of you all who are attending are the local Judicial Program ADA Coordinators, and this is some training that I've been talking about doing for a little while now. So for those who are not attending, like I said, this will be posted on the website along with some more materials. So I'm looking forward to presenting on this and getting some more of this information out there. I know I've spoken to a number of you over the years when you have questions or comments about ADA and accommodation requests. I've got my information up there. I think that is probably one of the best ways to handle a lot of these issues is just reach out to me and then we can kind of put our heads together and come up with solutions. So I just kind of wanted to start with that. Please don't ever be afraid to call me if you have a weird or any kind of ADA type request come in. So today's agenda, as I've mentioned, will be a general discussion of the ADA and Title II of the ADA, which applies to the judicial branch. We're also going to talk about then the actual judicial branch ADA policy, and then we will finish up with some common accommodation and modification requests. The ADA was first signed into law on January 26, 1990 by President Bush, Bush 1. You'll see the photo here. I thought it was kind of neat. That's in the Rose Garden there. I'm not going to read the names of who all was there, but this was a very important, monumental law that was passed in 1990. I think most of us now just take it for granted that the ADA was around, but this, it took a good at least 6 years of debating for it to actually come into law. And it actually came out of some of the civil rights laws that were passed in the 60s and 70s. So again, we take it for granted now, but this is still a relatively new law. It has really done a lot of great things for individuals with disabilities. So what is the ADA? The Americans with Disabilities Act is a federal law that prohibits discrimination against qualified individuals with disabilities. That was a mouthful. Enacted in 1990 and then was amended again in 2008 by President Bush, the other Bush, to kind of broaden the coverage and work out some of the kinks. Title II specifically of the ADA applies to the programs, services, and activities of state and local governments, including our judicial branch. What does Title II require? It requires such entities, us, to provide reasonable accommodations or modifications to those with qualified disabilities. What courts are covered? All the courts in Tennessee are covered. It's state, county, and municipal courts, so that includes the Supreme Court, the Court of Appeals, Court of Criminal Appeals, Circuit Chancery Criminal, Probate, General Sessions, Juvenile, and Municipal. So it captures everything, as does our judicial branch ADA policy. So how do we define disabled? Because the ADA prohibits discrimination against qualified individuals with disabilities. A person is considered disabled for purposes of the ADA if she or he has a physical or mental impairment that substantially limits a major life activity. So that's kind of broken down into three parts. The lawyer side of me likes to break this down into kind of the three elements of what is a disability. It's a physical or mental impairment that substantially limits a major life activity. So I'm going to touch on all three of these briefly. Looks like I've had some computer here. Hold on. Oh, there we go. It wouldn't be a Zoom webinar without some kinks here. So here, a physical and mental impairment. So like I said, there's physical and mental impairment that substantially limits a major life activity. So physical and mental impairments, there's all kinds. I mean, this is, as will be a common theme throughout this, we're going for very broad coverage of the ADA. So examples of physical and mental impairments will be paralysis, amputation, and other mobility impairments, blindness and low vision, deaf, hard of hearing, deaf, blind. Those are the communication disabilities we'll talk about. Schizophrenia, PTSD, bipolar disorder, and other personality disorders. Intellectual disabilities, Alzheimer's, and other those type of cognitive impairments. Those who are on the autism spectrum. Learning disabilities such as dyslexia, cerebral palsy, multiple sclerosis, speech impairments, epilepsy, heart disease, cancer, diabetes. Again, these are just examples. It is a very broad definition of what is a disability. Where the rubber meets the road is how do we accommodate for that? What kind of reasonable accommodations do we make? And again, we'll get into that later. So we start with a very broad definition and then we get into, okay, how do we accommodate for that disability? We have some of those I mentioned before are sometimes referred to as the invisible impairments or invisible disabilities. Not all disabilities are obvious. The ones that somebody comes in a wheelchair or is deaf or blind, sometimes those are a little more obvious. The invisible disabilities, intellectual disabilities, cognitive issues, those do substantially limit a person's ability to engage in major life activities. I know sometimes I don't want to say we roll our eyes, but those are just difficult, and I understand they're difficult, and those are the ones that definitely give me a call and we can walk through because they are disabilities and they do require some sort of reasonable modification or accommodation. Substantially limits a major life activity. Substantially limits is to be construed broadly and is not intended to be a demanding standard. It's Code of Federal Regulations that implement the ADA. Major life activities include, but are not limited to, performing manual tasks, seeing, hearing, walking, standing, sitting, speaking, breathing, reading, communicating, and any of the major operations of a major bodily function. So again, we're very broad in these definitions. It is going to be an individualized inquiry. The lawyer side of me loves using the case-by-case basis that, the determination of whether an individual has a disability and then the appropriate accommodation is going to be an individualized inquiry, and each decision is therefore made on a case-by-case basis. Again, that there's not a one-size-fits-all, and there's not a one-size-fits-all based off of the disability. There's not a one-size-fits-all based off of the major life activity. Again, this is just a case-by-case basis, and I'll kind of get into this when we get into the policy of how we handle these. The 2004 amendments, again, I keep talking about this broad coverage, and that was kind of the genesis of the need for these amendments. Again, the ADA was first enacted in 1990, and then after about 10 to 15 years of implementing the ADA, there had begun to be some issues with how it should be implemented and how strict of what is a disability and does it substantially limit your major life activity? So it basically, these amendments came out of that to say, okay, let's stop worrying so much about whether somebody is disabled or how disabled somebody is, and let's look to, okay, it's a very low standard on disability. Now let's look at what we can do to accommodate for that. So the ADA, the 2008 amendments, the ADA states that the definition of disability should be construed broadly in favor of expansive coverage. It makes it absolutely clear that the ADA is intended to provide broad coverage to protect anyone who faces discrimination on the basis of disability. Congress wanted the focus to be on ensuring that people have an equal opportunity to participate and are not discriminated against, rather than on whether someone meets this narrow definition. This is very important right here. It generally should not require extensive analysis. The disability portion of this should not require extensive analysis. I know when folks call me up, sometimes they want to get caught up on that, and we just need to take that as again a low standard, and then we work to what can we do to accommodate this disability. I provided you a picture of the 1990 inaction, and here's the 2008 amendments. There's Bush II signing. You can see his father there in the top left. So the legal nerd or the political nerd in me found it fascinating that it was the two Bushes that did the 1990 enactment and the 2008 amendments. It has not been amended since. Obviously, there's case law out there that interprets this, but I'm not going to get into a lot of that for purposes of this presentation. Okay, so where the rubber hits the road is these accommodations or modifications. Title II of the ADA requires that the Tennessee court system provide reasonable accommodations or modifications. And just briefly, I keep using both of those words because those are used interchangeably. You make an accommodation to somebody or you're modifying something, a court practice. So those are used interchangeably. Again, they are the same thing. This is how we make it so that a qualified individual with a disability can access the court system. Accommodations and modifications that are granted by the courts or the local judicial branch ADA coordinators are made at no cost to qualified individuals with disabilities. That's very important. We do not pass the cost on to the individual with a disability. The thought here is we are leveling the playing field, that it doesn't cost anything for me to walk into a courtroom, therefore it shouldn't cost somebody, you shouldn't have to charge the person to access a wheelchair ramp, or we had to spend this amount of money to build a wheelchair ramp, therefore people with wheelchairs now have to pay a tax to use it, those kind of things. I mean, I know that's obvious, but when we get into the more of the tricky ones, we just have to remember that this is not a cost borne by the individual with a qualified disability. The type of accommodation and modification is the key inquiry. I've said that 100 times and I'll keep saying it. The reasonable standard applies. That is, again, a very legal term. What is reasonable? It's going to really be made on a case-by-case basis. We don't have to make unreasonable modification, granting unreasonable modification requests of, we're going to have court out in my front yard because I can't make it to court. Those kind of things. That's not a reasonable accommodation request. So that's the key word there, reasonable. It has to be a reasonable accommodation or modification. Reasonable accommodations or modifications. Under the ADA, the courts must provide reasonable accommodations to enable a qualified person with a disability to fully participate in or benefit from a program or service. Courts are also required to make reasonable modifications to policies and programs to afford qualified individuals with disabilities an equal opportunity to enjoy court programs, services, and activities. There is a wide range of accommodations that the court may provide. And again, here we go. The appropriate accommodation depends on the circumstances of each case. I will keep pounding my drum on that. It's a case-by-case basis. Some of these are going to be very straightforward. If you have a deaf person who understands ASL or sign language, that's an easy one. But the other ones get a little funky, get a little tricky. Again, I've got my contact information. You've seen my email address. When those kind of ones come up, feel free to give me a call and we can walk through it. A number of you do that. I've got some of y'all are frequent flyers on that, and I don't mind it whatsoever. Please call me. I think one of the most important things to remember here is handling this on the front end. The ADA is kind of scary in terms of the liability that can come along with it. But if we handle it on the front end, we avoid a lot of these liability traps. So again, don't be afraid or nervous or whatever. Just give me a call if you have one that's really kind of funky or tricky. And those of you who are new to this, I know a lot of you sent me emails that there are new local coordinators in place. So also, again, make sure that you understand that you can call me. Okay, examples of accommodations. Architecturally renovating facilities to make them readily accessible and usable to individuals with disabilities. Those are the wheelchair ramps, those type of things. We don't see much of that anymore because I think a lot of our courthouses and other things have been, to the greatest extent possible, have been renovated to allow for that. So you don't see that as much. Relocating a service to enable a person with a disability to participate. That doesn't happen very often, but it's out there. Obtaining or modifying equipment or devices, including video phones, TDDS, assisted listening systems, video text display, or publishing materials in Braille and large print. These are the big ones. Some of y'all have assisted listening devices, other of you don't. That's something you may want to get with your county on, just to make sure those are still working. A lot of that system goes out of date easily, so just that's something you may want to look at. Providing qualified readers and interpreters. Interpreters is a huge one. That's probably the most common request we get in, and that's sign language interpreters, obviously not foreign language interpreters. Providing reserved parking for a person with a mobility impairment. Again, there should be handicap parking. And service animals. That's another one that's been coming up a little bit more and more, and I'll get into the difference between a service animal and an emotional support animal. There's a big distinction. Service animals, you gotta let them in. Emotional support animals, you don't. Communication disabilities and those accommodations. As I've mentioned a couple times, the sign language interpreting one is probably one of the most common types. So this, I've called them communication disabilities and the corresponding accommodations. This is probably the most common types of a disability and corresponding requests seen in our court system. Again, under Title II, we are required to take steps to ensure that our communications with people with disabilities are as effective as communications with others. That is known as effective communication. So whatever is written or spoken must be as clear and understandable to people with disabilities as it is for people who do not have disabilities. I'll make a little note here that that doesn't mean somebody has to come in and explain the legal intricacies of what is going on. Because many people who do not have disabilities don't understand what's going on in court. So this is more just a real baseline of we're leveling the playing field, that they just have to be able to communicate what is going on, maybe not fully understand the legal implications. It has to be similar to what a lay person would be. And I'll kind of get into that. That's why we do not provide attorneys under the ADA. How do we do that? Courts are required to provide necessary auxiliary aids and services to those individuals to ensure effective communication and participation in our services, programs, and activities. Auxiliary aids and services. An auxiliary aid or service is any device or aid that is designed to provide effective communication for participation for individuals with disabilities. Again, I keep pounding the drum on sign language interpreters, also these assisted listening system. So it's kind of a large term used, but they all kind of fall under that. So that may be something to go and look at what your courtrooms have or what they don't have, and look into whether that's something that you all want to get or update. Give primary consideration to the aid or service preferred by the individual, because that individual is usually best able to identify the communication barriers that hamper participation. Again, this goes back to the case-by-case determination. There are people who are hard of hearing and not able to do sign language. There are people who are fully deaf and cannot do sign language. There are, you've got to figure out what this individual prefers, and then we see if we can provide a reasonable accommodation. You get that sometimes with the assisted listening systems too, because sometimes they don't work well with the individual's hearing aids. So again, we have to kind of give that individualized inquiry case-by-case basis. So on these auxiliary aids and services especially, just talk to the person or communicate with the person to figure out what they use or what they do not use, or what can be compatible with what they use. All right, what is not required? This is very important here. Again, we start with the premise that we are going to help, we are going to do what we are required. However, there are exclusions and limitations as to what we can do in our role as ADA coordinators. Specific examples of exclusions are transportation to the courthouse. We do not provide transportation to the courthouse. I get that call probably once a month. I'm disabled, I can't get to the courthouse. That the ADA makes it clear that it's not us saying that, it is the federal law that it does not reach to providing busing or cab fare or Uber or whatever to the courthouse. That is not what it is. It's just access to the courthouse, not transportation to. Also, it does not provide for legal counsel or advice. This is probably the other one I get the most calls on. I'm disabled, I need an attorney. That's, again, the ADA does not provide for that. There are other ways to handle that, whether it's in a criminal setting or a civil setting, of what the parameters are on that, but that is outside the scope of the ADA. Personal devices such as wheelchairs, hearing aids, or prescription eyeglasses. Again, I need a wheelchair. Some courthouses have that and can provide some, but these personal devices are not required. So again, I can't hear really well, I need hearing aids. Those are his or her personal devices. Again, that's different, a little different from like an assisted listening system that is within the court itself. Personal services such as medical or attendant care. Again, I need a nurse to provide 24/7 care. We're not going to provide that. We don't have nurses on staff at the courtroom to do those type of things. So that's kind of the really what we do not provide. These are the exclusions. There are also lots of limitations, the general limitations. The ADA does not require the court system to take any action that would, and I'm going to get very legal here, fundamentally alter the nature of court programs, services, or activities, or that would impose an undue financial or administrative burden. Fundamentally alter the nature of the program or undue financial or administrative burden. These are the two hooks that a lot of times we will find accommodation requests not to be reasonable, because, again, I want you to appoint an attorney for me. That's fundamentally altering the nature of the court or the program services. Or I want to have court in my living room. No, that's, again, fundamentally altering. That's probably also an undue administrative burden of moving everybody to that person's living room. So these are kind of the two hooks that we look at to say, okay, maybe this is not a reasonable request. Again, these limitations that impact court proceedings. This is really important. That's why I put the 3 little stars and put it in bold. ADA coordinators cannot administratively grant an accommodation request that impacts court procedures within a specific case. That's a mouthful. What does that mean? We cannot grant requests for extension of time. Hey, I need 30 more days to file an answer. No, that is not an accommodation request. That is a motion for more time. A change of venue. Hey, I'm disabled. I can't come to this court, move it over to this county. No, you would file a motion for change of venue. Participation in court proceedings by telephone or video conferencing. Again, that's a lot of the courts are doing that now. You can pass that along to the judge or judicial assistant. But that is something the judge controls what goes on in the courtroom. So those type of things go, when you get those requests, let the person know that is not a proper ADA request, and tell them that they either need to file it with a court. You can also, if you feel comfortable and know the judge, you can also say, hey, we received this. Some judges will say, okay, I'm going to treat this as a motion to do this or as a motion to do that. And then the judge obviously may consider the individual's disability along with other relevant factors in granting or denying the motion, but that's not what we're doing. We're not the judge. I'm not a judge. You're not a judge. We're not granting or denying motions. We're doing accommodation requests. So this is very important. Flag this, bookmark this. Just remember that this is where, again, this is also a very common thing that we get questions on. So, we cannot give you more time. We can't, again, dismiss a case. We can't, set aside a dismissal, those type of things. That's just way outside what we do. Requests that exceed the law. These are also accommodation requests that we cannot do. We can't exceed the law in granting an accommodation request. An example is we can't extend the statute of limitations. I kind of mentioned that, I need 30 more days to file something. If that silly makes it outside the statute of limitations, we as an ADA coordinator cannot do that. that she or he cannot make it to court on time because of a disability, nor can an accommodation modify the terms of an agreement among parties. Again, if they've entered into some type of settlement agreement or something along those lines, the accommodation request cannot touch that. Again, these are administrative type functions of allowing the person to have effective communication or effectively be a part of the court proceedings, not actually in the case itself. That is for the judge to decide. All right, how do we implement this in our courts? We have the Judicial Branch ADA policy. That's policy 2.07. It is found on our website. There's the link there below. You can just go to tncourts.gov, kind of play around on there. Sometimes if you scroll to the bottom left of the page, you'll see a little ADA link itself on the main page. Click that. That will pop this up. They'll show you, it'll have the policy, it'll have all kinds of great information on there. I would bookmark it or do whatever you do with web pages. I've got it favorited. I've got it on every computer I use because it's just easy. You pull it up, bam, there's the policy, there's all the information. So this policy controls how we implement the ADA. So I've been speaking about the ADA generally, but this is, okay, how do we actually handle these accommodation requests to make sure we're in conformity with the ADA? So policy 2.07. Why do we have the Judicial Branch ADA policy? We didn't have one up until the mid-2000s. That caused an issue. That caused a very major issue. It actually made it all the way to the United States Supreme Court in Tennessee v. Lane. Some of you all may recall this, some of you may not. Real briefly, it involved individuals with disabilities. A couple were court reporters, and one was actually a defendant in a criminal case who could not access the upper floors in certain courthouses. And even one of these individuals ended up having to crawl up 2 flights of stairs. So just not a good fact pattern. I'm not going to get into the real legal part of this case. It gets super legal nerd. We just, it's not important for what we're talking about here, but this is a major United States Supreme Court case, and that's where we were kind of told we need to have a policy. So the outcome, the Supreme Court obviously found in favor of the plaintiffs. That ended up resulting in a settlement with the plaintiffs that required the adoption of a Judicial Branch ADA policy, that we provide education and training on the ADA policy. And why do we have you all? It required local judicial program ADA coordinators. That is you all, and yeah. How did we get to this point? The Supreme Court enacted Rule 45, which basically told the AOC to implement an ADA policy. So I won't get too much into that. So Supreme Court Rule 45 authorized, again, the AOC to enact a policy to make sure we're compliant with the ADA. So we enacted policy 2.07 there in the mid-2000s. I think 2007 or 8, somewhere in there is when it came on board. Here is the language. It shall be the policy of the judicial branch of the state of Tennessee to prohibit discrimination against any qualified individual on the basis of physical or mental disability in accessing or participating in its judicial programs. The judicial branch shall conduct its services, programs, or activities when viewed in their entirety in a manner that is readily accessible to and usable by qualified individuals with disabilities. So that is kind of our mission statement here of why and how we do this. There are a couple positions that are created under this policy. The Judicial Branch ADA Coordinator, employed by the AOC and oversees the administration of this policy currently. That's John Cope, this guy right here. So I am the Judicial Branch ADA Coordinator, sometimes called the statewide Judicial Branch ADA Coordinator. Either way, John Cope. I've got my information on there. I'm your point of contact for the foreseeable future on these type of things. It also required these local judicial program ADA coordinators, aka you all. There has to be at least one for each county in a judicial district who will be responsible for handling all these requests for modification or accommodation to access the judicial programs, activities, and services within that county. Many counties have many local judicial program coordinators. The big counties typically sometimes have one for the state trial court, such as civil, criminal, chancery, one for maybe the general sessions, another one for municipal. It just depends. I mean, the main thing is we at least have one of you all for when somebody in, let's say, Johnson County says, I'm going to general sessions court and I need an interpreter. We need to have a person there in Johnson County who says, I am that person. Reach out to me. I will get this taken care of. So we try our best to keep this updated on our website. Again, unfortunately, a lot of people leave their positions and fail to tell anyone that, hey, I was the local judicial program coordinator. So when somebody new comes on, suddenly we don't have one. We try to keep our lists updated. So obviously, if you all are attending this or watching this, you know you are. But we really try. But I also really rely on you all. For the actual appointment of that, it's very generic. I leave it up to you all of who wants to be that person. A lot of it will be some of you are court clerks, some of you all work in county government, some of you all work for a judge. It doesn't really matter. We just have to have that person, that point of contact to handle these requests coming in. So what is the procedure? And this is all laid out in the policy. And again, I really recommend you pull up the policy and read it. Persons requiring modification should contact the local judicial program ADA coordinator. The list of you all are actually found on our AOC website. You'll see that on the ADA policy and ADA contacts. It's a little pull down screen where they pull down by county, and all you all will then pop up by county. The procedure requires, but again, whenever we say requires with the ADA, it is not hard and fast. So we really prefer that a written request be used, and that we really prefer the request for modification form that is used. It's within the policy itself, and there's also a link to the request form. But again, however requests may be made over the phone or in court, those requests should be committed to writing by the local coordinator. I know these things happen quick. Just document, do something, email me, email somebody within the office, fill out the form, make some kind of record of this request coming in, because those are when we kind of get in trouble. Is person A says, I made this request, you all said we granted it, and then something happens and we don't have any documentation that either A, the person made it, or B, we granted it. So try your best to make a record and then maintain those records. So that is very important. And I know a lot of you all, again, wear multiple hats at your job. So, but just try your best and really make records of these things. Who can request? It is not just the disabled individual with the disability. It may be submitted by a lawyer, party, witness, juror, or other individual with an interest in attending any judicial program, activity, or service, or another person on behalf of such an interested person. So again, it doesn't have to come from the actual person with the disability. It can come from a family member. It can come from his or her attorney. As you see, it does allow for accommodation requests for a witness, for a juror, somebody who wants to attend court and just watch. With those, it then becomes the reasonable determination. If somebody's just wanting to come and watch court and has a disability, that gets a lot trickier, because what is a reasonable accommodation for that? Do we provide sign language interpreters for somebody who just wants to come and watch just court for a day? It just becomes, is that reasonable? Is it an undue financial burden? Typically, we will work out some kind of agreement with this individual. So the time for requests should be submitted with as much advance notice as possible, but should be made no less than 5 business days prior to the date for the modification is sought. Again, 5-day rule, not hard and fast. We're not going to typically deny because somebody didn't get it in within 5 days, but this is just something to stress to people when they make these requests. The more time you give us, the better accommodation or modification we can provide. Untimely requests, if not timely, the court or the local coordinator in its discretion may grant it. The reason I say the court here, because a lot of this may probably happen while in court. Somebody says, I can't hear well, or I can't see, or there's some kind of, it first presents itself while in court. So sometimes that will be actually granted by the court and not the ADA coordinator or local coordinator. The court may also postpone, reschedule, or otherwise delay a program, service, or activity affected. In these cases, the individual is directed to then submit a written request. I advise against too much postponement, rescheduling, or delaying programs. That there's case law out there that is kind of going against some of the purpose behind the ADA, but sometimes it's just if we have not been given timely notification, we just can't get somebody there. It has to be postponed. But it's one of those, if somebody's giving you a lot of heads up, we don't want to postpone or move it to a different time just for that person. That goes against, again, the ADA. We're not trying to treat them differently. We're trying to level the playing field and treat everybody equally as if they didn't have a disability. So if we start saying, okay, if you have this disability, you then come to a court hearing at this time, again, there's case law out there. We want to avoid that. But again, if it's an untimely request and we don't know, obviously we have to do our best there. So it may require a continuance. And again, that will be on the judge to do that. The actual coordinator will, when these requests come in, they review the request, and then you all will either grant, deny, or provide an alternate modification. You can also request additional time in order to achieve or obtain the modification. Again, don't sit on these things. When these come in and they're not easily handled, give me a call. We'll get it sorted out. I'll walk you through how to grant, deny, or provide alternate modifications. I advise against a denial absent those really reasons I talked about earlier. I always ask that we see if we can come up with an alternate modification. Grounds for denial, and this goes back to some of the stuff we touched on earlier. These are the actual grounds found within the policy. These come out of what I was talking about earlier of what we can and cannot do. Obviously, we won't grant one for somebody who is not a qualified individual with the disability. Be careful with that one. We really try not to use that one unless somebody's just completely faking it, and even then, that's not the road we want to go down. These are the ones that I do kind of look more favorably on when we're going to look to deny or provide an alternate modification request. An undue financial or administrative burden, or the fundamental alteration of the nature of the program. Again, those are kind of funky legal words, but that's undue financial burden. It costs too much. Administrative burden, it would just be too hard for us to do all this. Fundamentally alter, again, having court in somebody's living room. Those are the kind of things those are what that means. You can also then, like I said, provide an alternate modification that would be as effective and involve less cost or convenience. Refusal to comply with the policy, you can deny on that ground. Again, I would advise against that, absent extraordinary circumstances. Failure to comply with the policy makes it impossible or impractical. The ability to provide the requested modification. That's kind of a catch-all, that if somebody's just being extremely difficult and we just can't do it, that will kind of be a last resort. So typically I look at denial or providing a alternate under this undue financial burden, administrative burden, or fundamental alteration. Those are where I think you all will want to kind of key in on when examining these. Absent, again, the ones we're not going to drive you to court, we're not going to provide you an attorney. Those are the easy, we don't do those, deny. Appeal. Again, this is an administrative policy. This is not within the court itself, but if the request is denied or the offered alternative request is unsatisfactory to the qualified individual with a disability, that person may appeal the decision, y'all's decision, the local coordinator, to the presiding judge of the judicial district within 10 days of the denial. So you all may want to look up who the presiding judge of your judicial district is. I know our presiding judges are aware of this. In 5 years or so in this position, I have not had to take one to a presiding judge. So my point there is we try to get these worked out before that, but it does technically go up to the presiding judge for that judge to then look at and make a decision. If the applicant is unhappy with the ruling of the presiding judge, she or he may appeal again within 10 days to the director of the AOC. So that will come up to us. Director Michelle Long and myself will review and make a determination. And then at that point, the process is over. Again, this can't be appealed to the Court of Appeals or the Tennessee Supreme Court. This is just straight administrative accommodation requests. This does not go into those type of things. Again, it's never made it to the presiding judge, so it's definitely not made it to the director or myself. So knock on wood on that one. Going into the appeal here, this probably isn't super important for you all, but she right now is authorized to independently investigate the facts surrounding and has the discretion to utilize appropriate alternative dispute resolution procedures. The director's decision is final. All right, I have now been through the ADA Title II and how that applies to the government agencies and then our specific policy. I don't know if any questions have come up yet. Nope. All right. I'm just doing such a great job, apparently. So now I'm going to get into kind of examples of these issues that maybe come up frequently and or ones that I just think deserve some attention. First one is service animals versus support animals. Then the accommodations for mental or cognitive impairments. I've presented on this before, really a fascinating area. And then sign language interpreters, and that there is actually a statute out there that actually works almost somewhat in conjunction with the ADA. It actually predates the judicial branch ADA policy, but not the actual ADA itself. And that just deals with sign language interpreters. So I'll touch on all three of these briefly. We have about 15 minutes. I'm trying to keep this to an hour. Service animals. A service animal is an animal that is specifically trained to perform tasks for an individual with a disability. This is different from an emotional support animal. Again, this is super, super important. Service animals versus emotional support animals. Unfortunately, the line, I think, is somewhat blurred now just because of the increase in the use of emotional support animals, which, again, I have absolutely no problem with people having emotional support animals. The science is there. These are great things for people with cognitive disabilities and other things that, these, that it really helps them. And again, the support animals just helps them be calm and, versus when we actually have a service animal. And that's where I put up this definition because to cut to the chase, if it's a service animal, we have to allow it into the courthouse and into the courtroom. Emotional support animals, we do not. Emotional support animals are not covered under the ADA. Service animals are, and it is, you allow them in. We can get into a lot of trouble if we are not allowing a service animal in. So that's why, okay, what is a service animal? It is specifically trained to perform tasks for individuals with disabilities. Examples is guiding a person who's visually impaired. Again, those are, we've seen those. The other ones are a little more interesting, but becoming a little more common. Alerting a person who is deaf or hard of hearing, pulling a wheelchair, assisting with mobility or balancing. We've had that come up, that I have a service dog because I fall, or I have other, that it was some kind of cognitive or disability that she would lose her balance often. And this dog was specifically trained to make sure that doesn't happen. Alerting and protecting a person who is having a seizure. Again, I mean, I think we've all seen the videos out there, just amazing, incredible that the dog can understand that this is happening and does something, retrieving objects or performing other special tasks. Again, I know I'm just pounding the table on this one, but it is very important to make sure we figure out early on whether it's a service animal or an emotional support animal. A service animal is a working animal. It is not a pet. So again, it's, you know, we're not dealing with parrots or flamingos. We're not dealing with, you know, my emotional support miniature cow. This is a service animal, and the courts will allow people with disabilities to bring their service animals into the areas of the court facility where members of the public are normally allowed to go. Okay, how can we determine if this is a service animal? And again, this is in the ADA. It is limited to 2 questions. You may ask if that animal is a service animal, and or what tasks the animal has been trained to perform. You cannot require some kind of special ID card or something like that for the animal. So it becomes almost a credibility determination, and you know, it's one of those. I think there's an old United States Supreme Court case out there about how can we determine if something is obscene. It's, you know, whether something, there's obscene material. And the famous line is, you know it when you see it. So you should be able to determine and see, using kind of your common sense, that whether this is an animal that is specifically trained to do something, or somebody's trying to bring in their chihuahua because they are stressed at their divorce. So again, but you cannot be like, I need to see an ID or something along those lines. So it's clear, but also just watch out, because we can kind of get into trouble if we start asking too many questions about it. But so you may ask if is that a service animal, and what task has it been specifically trained to perform. You can't ask for a card. You can't say, does it have certain training papers? You may, on this, what task has the animal been trained to perform? If the animal is in training right now, that may cause some gray area. But, you know, just kind of use your common sense here that, you know, I think we've all kind of seen what is a service animal and what is an emotional support animal. You cannot ask that the person remove the animal from the court unless, and these are important here, the animal is out of control and the owner does not take effective action to control it. For example, a dog that is barking repeatedly during a court hearing, or the animal poses a direct threat to the health or safety of others. This may come up with somebody who's allergic to dogs, or somebody who's scared of dogs. Those are generally not going to be enough right there. You know, maybe the person with the allergies may need to move to the other side of the courtroom. Somebody who's scared, you may have them again move. The more direct threat is if it is a mangy dog. It is, you know, I mean, again, you know it when you see it, or it's some kind of, you know, super aggressive pit bull type animal that, again, probably shouldn't even be in there because it's probably not a service animal. So again, I think I get this question a lot, is, you know, what if the dog starts barking, those type of things. You know, I think we at least allow there to be an ability to be like, okay, can you keep your dog from barking? Again, if this dog is out of control, it's probably not a service animal, and that's probably a red flag that, you know, that this doesn't qualify as a service animal. So that's kind of how that works. In those situations where a service animal must be excluded or removed, the court should afford the person with the disability an option to continue participating without having the animal on the premise. The court is not required to provide food or care for the service animal, or provide a special location for it to relieve itself. You know, you've seen those in the airport, trying to think of the proper way, the dog relieving areas, you know. So, you know, we don't have to have that. You know, I do recommend that the court be aware, and that, you know, maybe let talk to the person, how often does this dog need to go outside and relieve itself so that we don't have accidents when in the courthouse. However, the judge is not required to have some milk bones or rawhide sticks up on its desk, to provide for the dog. So don't need that. All right, now the other one we get a lot of questions about are these mental or cognitive impairments. We get these a lot, and these are the most difficult ones to deal with. These are going to be the individuals with like mental health issues, developmental disabilities, or communications disorders. You're going to start probably hearing this term a little bit more, neurodiversity. It is often used to cover people who are on the autism spectrum disorder, or maybe who have ADHD, dyslexia, PTSD. So it's kind of a broad term that covers all these. So these are recognized disabilities. I think we are getting much better as a society now of recognizing that these are disabilities. I think there are still people that will sometimes roll their eyes about PTSD or these type of things. But I mean, the science is real on this, folks. These are real disabilities. And sometimes we don't even like using the word disabilities. This is a diversity for some of them. They have certain abilities that we don't have that makes them, diverse and those things. So again, it's important just to make sure you realize that these are disabilities and we do need to provide some sort of accommodation or modification. Examples of what I advise our coordinators and even judges about is modifying kind of the court schedule. So that these are going to go hand in hand with working with your judge about these. Is maybe modifying some court schedules, and I mean that, and again, maybe allowing more breaks if somebody needs, let's go no more than 30 minutes at a time. I mean, a lot of judges try not to go more than an hour or so at a time, because I think, people start losing certain abilities, even non-disabled people after, 30, 45 minutes. And I'm on 54 minutes in front of you, so you will probably know exactly what I'm talking about. Allowing note-taking and tape recorders, again, that the judge should be brought in on that. Allowing note-takers, that's where we kind of get into some vague gray area. Talk to me about that. I'll kind of walk you through what we do on that. Modifying the lighting, that's a big one. Just dimming the lighting a little bit. Limiting the time on the stand. Again, let's go for no more 30 minutes. Maybe talking a little bit more slowly, having the judge do that, using more simple language. These are the kind of things that we will look at doing, because unfortunately, when you have like PTSD and being in court, everybody's going to be stressed going into court. Absent maybe an adoption or marriage, when you're in court, you don't want to be there really as a litigant. The attorneys are attorneys, but the litigants really don't want to be there. And there's going to be stress. It's an adversarial position. It's an adversarial system. So there's always going to be some stress involved. So, we can't use a magic wand and make court just this magical wonderland where nobody's going to feel stress or have, anxiety. But we have to do at least something for those that are more susceptible to these. So again, we're not curing these disabilities, or we're not curing the effects of these disabilities. We're just reasonably modifying our court procedures to provide help for these individuals. Finally, there's a statute out there for the interpreters for the deaf and hard of hearing. A court is required to appoint a qualified interpreter when a deaf person is a party or witness. What is interesting is this interpreter can also assist in preparation with counsel. So that I've seen that be used a little bit in some out-of-court proceedings, but we advise against that. This is mostly just for interpreters in court. So this is an interesting statute, because we have our judicial branch ADA policy, we have the federal ADA, but then we actually have this specific statute. So I always kind of defer to this statute, TCA 241211, when we have a deaf or hard of hearing, because it lays out exactly what needs to be done. The most common question I get from you all, and the one as a state employee I answer immediately, is the interpreter is paid by the county. So this is, do not send invoices to the AOC, do not send it to the state. This is paid by out of the general county fund. You're going to have to go to your county mayor or county legislative body. They're probably not going to like it, but it is required, and you all will be, there's a lot of liability that goes along with not providing an interpreter. And we again, I think it was one of the first things I said is, this definitely is not going to be paid by the person with the disability. It's going to be paid by, in this instance, the county, or in other instances, the state, but a lot of it does fall on the county because of our non-unified court system. So I would highly recommend having that statute handy for when you have deaf and hard of hearing. That about wraps it up for me. I am just under 1 hour. I don't know. It looks like I did have a question come in, so it is being handed to me. This is from Amanda Bush. Do you feel as though local judicial ADA coordinators should be someone inside the judicial system as opposed to general Title II coordinators located in the department outside of the judicial system? That's a good question. Do we want somebody who's very familiar with the court system, or do we want somebody who's very familiar with the ADA? I think if it's the person who's not within the court system, I think it's probably important for them to find a contact, aka me, who can kind of walk you through, some of that, or find contacts within the court clerk's office to do that. So I don't want to say it can never be somebody who's not involved with the court system, because I know some of you all are within the mayor's office or within the county's ADA office. So I'm not going to say no, it should never be. I just say in those instances, talk to me if you want some more help on the court system, or just start reaching out to people in the court system and broadening your knowledge and understanding of the court system. Got another question. Bill over in Hamilton, great presentation. I agree. I see this is being recorded. Do you plan to send a link out that we can look back and share with others? Yes, Bill, 1,000%. I am going to be placing this. It is being recorded, and it will be placed on our website in that ADA section, so that when we all have new coordinators come on, we can direct them to watch this. Or if you just want a refresher, or for the people who are did not watch this and are now watching this for the first time, it's obviously been recorded. So yes, it will be recorded, and I will probably update it. I don't know how often, because again, a lot of this stuff is pretty well, there's not a whole lot of changes in this. We've been, there's not much new law out there in terms of the ADA. Brenda Green, what is AOC? I probably should have said that at the beginning. Well, I think I had it in my initial slide. The AOC is the Administrative Office of the Courts. So we are the administrative agency within the Tennessee judicial system, or under the Tennessee Supreme Court. So, but as part of the judicial branch ADA policy, and the Tennessee Supreme Court has tasked the AOC with kind of implementing this policy. So myself as the statewide judicial branch ADA coordinator, I monitor this policy. I work at the AOC. All right, I got one more. From Carly, if the judicial ADA coordinator also serves as a court clerk, does this pose a conflict of interest as far as offering services on the ADA side? This may be too broad and may be answered on a case-by-case basis. It really shouldn't be a conflict. Give me a call if you have conflict issues. Again, these are really administrative type functions, so there shouldn't be a conflict involved with administrative, but there's so much gray area involved here. So as with anything, My number's up there. My email, I have 2 email addresses. I'm so special. No, but that, again, as ADA coordinator, I have that. I also have my personal work email address, and then there's my phone number. It looks like I have answered all the questions. I am 2 minutes over an hour, but I think we started maybe a minute and 30 seconds late. So I'm patting myself on the back for doing an hour. I thank you all for watching this. I thank you all for doing what you do. I know it's not easy work. It may not come up very often. It may be stressful at times. I am here for you. I am here to help. If that's the biggest takeaway, this final slide is it. Call me. I'll help you. So thank you. Have a great day.